This video presentation is brought to you by YourOnlineProfessor.net. Presents the Patient Protection and Affordable Care Act, Tax and Nontax Provisions. This course will count for 1 hour of CPE or Pennsylvania CLE credit. The field of study is taxation, non-interactive self-study. The program level is basic. There are no prerequisites and no advanced preparations required. This course will provide an overview of both the tax and non-tax provisions in the Patient Protection and Affordable Care Act, a federal statute signed into law by President Barack Obama on March 23, 2010. After reviewing this course, you will have the opportunity to take the quizzer. If your score is less than 70%, you may retake the quizzer as many times as you like until you answer at least 70% of the questions correctly. This program was designed and developed by Edward Perkins, J.D., LLM, Tax, and CPA. Partner of the immediate Pennsylvania-based law firm of Gibson and Perkins, P.C. Adjunct Professor of the Villanova University School of Law's Graduate Tax Program. And founder of YourOnlineProfessor.net. YourOnlineProfessor.net is registered with NASBA as a sponsor of continuing professional education on the National Registry of CPE. Our sponsor number is 108594. Where applicable, this program is copyright YourOnlineProfessor.net, all rights reserved. This material is designed for informational purposes. In providing this material, neither the author nor YourOnlineProfessor.net are engaged in rendering legal, accounting, or professional service. If such service is required, the service of a competent professional should be sought. Inquiries regarding the use of the material contained in this course should be addressed to YourOnlineProfessor.net, Suite 204, 100 West 6th Street, Media, Pennsylvania 19063. YourOnlineProfessor.net presents the Patient Protection and Affordable Care Act, Tax Provisions.
Tax changes relating to universal health coverage mandate. Penalty for remaining uninsured. Effected for tax years beginning after December 31, 2013, non-exempt U.S. citizens and legal residents would have to maintain minimum essential coverage or pay a penalty. Those failing to maintain minimum essential coverage for 2016 would be subject to a penalty equal to the greater of 2.5% of household income over the threshold amount of income required for income tax return filing, or $695 per uninsured adult in the household. The fee for an uninsured individual under the age of 18 would be 1/2 of the fee for an adult. The total household penalty wouldn't exceed 300% of the per adult penalty, or $2,085, nor exceed the national average annual premium for the bronze level health plan offered through the insurance.
Exchange that year for the household size. The per adult annual penalty would be phased in as follows: $95 for 2014, $325 for 2015, and $695 for 2016. For years after 2016, the $695 amount would be indexed to CPI-U, rounded to the next lowest $50. The percentage of income would be phased in as follows: 1% for 2014, 2% for 2015, and 2.5% beginning after 2015. If a taxpayer files a joint return, the individual and spouse would be jointly liable for any penalty payment. The penalty, which would apply to any period the individual does not maintain minimum essential coverage, determined monthly, would be assessed through the code.
Among those individuals who would be exempt from the penalty: individuals who cannot afford coverage because their required contribution for employer-sponsored coverage or the lowest cost bronze plan in the local insurance exchange exceeds 8% of household income. Those who are exempt for religious reasons, and those residing outside of the U.S.
Low-income tax credits for participating in health exchanges. For tax years ending after 2013, tax credits would be available for individuals and families with incomes up to 400% of the federal poverty level, $43,420 for an individual, or $88,200 for a family of 4, that are not eligible for Medicaid, employer-sponsored insurance or other acceptable coverage. These individuals and families would have to obtain health care coverage in newly established insurance exchanges in order to obtain credits. Additionally, effective on the enactment date, a cost-sharing subsidy would be provided to low-income individuals to help with health insurance costs.
Employer responsibilities. Effective for months beginning after December 31st, 2013, an applicable large employer, generally one that employed an average of at least 50 full-time employees during the preceding calendar year, not offering coverage for all its full-time employees, offering minimum essential coverage that is unaffordable, or offering minimum essential coverage that consists of a plan under which the plan's share of the total allowed cost of benefits is less than 60%, would have to pay a penalty if any full-time employee is certified to the employer as having purchased health insurance through a state exchange with respect to which a tax credit or cost-sharing reduction is allowed or paid to the employee. The penalty for any month would be an excise tax equal to the number of full-time employees over a 30-employee threshold during the applicable month, regardless of how many employees are receiving a premium tax credit or cost-sharing reduction, multiplied by 1/12 of $2,000.
Also, an applicable large employer that offers, for any month, its full-time employees and their dependents the opportunity to enroll in minimum essential coverage under an employer-sponsored plan would be subject to a penalty if any full-time employee is certified to the employer as having enrolled in health insurance coverage purchased through a state exchange with respect to which a premium tax credit or cost-sharing reduction is allowed or paid to such employee or employees.
Free choice vouchers. After 2013, employers offering minimum essential coverage through an eligible employer-sponsored plan and paying a portion of that coverage would have to provide qualified employees with a voucher whose value could be applied to purchase of a health plan through the insurance exchange. Qualified employees would be those employees who do not participate in the employer's health plan, whose required contribution for employer-sponsored minimum essential coverage exceeds 8% but does not exceed 9.5% of household income, and whose total household income does not exceed 400% of the poverty line for the family. The value of the voucher would be equal to the dollar value of the employer contribution to the employer-offered health plan.
Tax credits for small employers offering health coverage. Effective for tax years beginning after 2009, a qualified small employer would be given a tax credit for non-elective contributions to purchase health insurance for its employees. A qualified small business employer for this purpose generally would be an employer with no more than 25 full-time equivalent employees, FTEs, employed during the employer's tax year, and whose employees have annual full-time equivalent wages that average no more than $50,000. However, the full amount of the credit would be available only to an employer with 10 or fewer FTEs, and whose employees have average annual full-time equivalent wages from the employer of less than $25,000.
These wage limits would be indexed to the Consumer Price Index for urban consumers for years beginning in 2014. For tax years beginning in 2010 through 2013, the credit would be 35% for small employers with fewer than 25 employees and average annual wages of less than $50,000 who offer health insurance coverage to their employees. In 2014 and later, eligible small employers who purchase coverage through the insurance exchange would be eligible for a tax credit for 2 years of up to 50% of their contribution.
Dependent care coverage in employer health plans. Effective on the enactment date, the health reform measure would extend the general exclusion for reimbursements for medical care expenses under an employer-provided accident or health plan to any child of an employee who has not attained age 27 as of the end of the tax year. This change would also be intended to apply to the exclusion for employer-provided coverage under an accident or health plan for injuries or sickness for such a child. A parallel change would be made for VEBAs and 401h accounts. Also, self-employed individuals will be permitted to take a deduction for any child of the taxpayer who has not attained age 27 as of the end of the tax year.